everyone. So today we are meeting for the second session of Legal Update Special Edition, the CLAT. In the last class, we covered some of the legal updates, very important ones. And in today's session, again, we have come with some very important legal updates in the examination. So let's very quickly start with the first one. Judicial recusal. I hope by now, if you are consistent with your mock tests, you would have come across at least 2 to 3 passages on judicial recusal. Plus, uh, those of you who are consistent with your newspaper reading, you would also have come across judicial recusal by now several times in the newspaper. Yes, so this is something which has been in news and which is like a contemporary topic, and it keeps coming in the newspaper and in news, your mock test. Yes, so it becomes an important part. So starting with the meaning of recusal, uh, it basically means a situation wherein judge basically declines to take part in a judicial activity, even in a judicial court, right? Suppose there's a case wherein a judge has some kind of interest in that case. Maybe it can be a personal interest or pecuniary interest or any sort of interest. So what happens when a judge has an interest? That will automatically would come in the conflict of the interest of the justice, right? And since it would come between the justice and the parties, the judge's interest would come. Hence, he cannot be expected to be completely impartial in that situation. Yes, because human element comes into that picture, human element of a biasness, right? So when you have any kind of interest or when you have any kind of I vested interest basically in a particular case, there are chances that you might not be impartial, you might not be completely fair in that case. And following that jurisprudence, uh, this particular concept runs, right? Judicial recusal. Now, uh, why are we like talking about it? Because recently there have been certain cases wherein Supreme Court the judges of Supreme Court stepped down from uh, taking up a case and following that case, basically. Let's look more into it. Talking about the principle, I hope by now you would have come across this legal maxim of nemo juris in sua causa. It basically means that a person cannot be a judge in its own case, right? So where a judge has its own interest, that judge cannot be a judge between those two parties in that case, right? Why? Because it is believed, it is a universal belief that justice is not only supposed to be done, but it is supposed to be seen as well, right? So until unless it does not seem like justice is being rendered, we cannot say that justice has been done. All right. Other than that, why do we follow this? Why judges follow it? Because of the oath. They take oath while they're appointed, when they're getting appointed in office. And in that oath, they take the oath of being fair, right? So it also comes from there. And has been certain instances, like recently in a case, there was this likelihood of a judge being impartial, and on that basis, judge stepped down from that case. And recently, in the same-sex marriage case that we discussed in our last session, there also the Chief Justice rejected the application that was seeking for his recusal. Right. So that was about the recent cases. Now, why do judges recuse? I guess by now you would have gotten a good amount of understanding on that. And how does it take place? Means what is the procedure? There is no codified procedure for that. Means there is no law which has mentioned about it. We have taken it through principles and all these oaths and all of these instances. We have pulled this concept of judicial recusal and we have been following it. There's no law that talks about it particularly. Other than that, we have two kinds of recusals. One is the automatic one, where the judge uh, himself decides to get out of the case. And there is another one wherein the party files a recusal of a judge. Right? So these are the two kinds. Other than that, can a judge be forced? No. Judge cannot be forced to get out of the bench. Okay, why? Because it will completely be dependent on the discretion of the judge to decide whether they want to continue with that case or not. And no party can force a court, a judge, or they cannot compel a judge, right? So that was important. Other than that, are these judges required to record their reasons for refusal? See, again for this, there's no law as such because we have no law on refusal. However, there have been certain judgments wherein judges have sort of debated about it, and it is left up to the judges to decide whether they want to record any reasons or not. But again, it attracts some kind of challenges, some kind of decision here. Why? Because if there are no reasons that are stated, it would again, uh, cause some kind of not being so transparent, or I mean that a non-transparent side of the judiciary, because uh, people are left open to just guess about it, and they are not allowed to get into or to know about the or to investigate into the procedure as such, and hence it becomes it remains ambiguous and sort of vague and uh, sort of blank for people to know about it. Other than that, there have been certain rules, right, that Supreme Court has laid down over the years in the matter of judicial recusal. Like, for example, first one is that there has to be reasonableness of the apprehension of data. Just because a party has somehow dreamt, सुबह उठ के आए और उनको सपना आ गया कि जज दूसरे party को favor करने वाले, just because the party has just simply dreamt about it, it is not going to work. They have to come up with a very solid reason. There has to be certain reason, a reasonable ground on the basis of which that apprehension resides. That is one. Second is that you'll have to prove that the situation, that the case is such that judge is incapable of being impartial. Yes, it's not just that you're doubting it. No, you have to prove that yes, judge is incapable as per all these facts and whatever you lay down on the table. Yes, so very important. Uh, Moving on, the next thing that we have, and the next update is with regard to NHRC. I'm sure again this is very, very important body uh, in our country of NHRC, National Human Rights Commission. And it becomes important, but important with respect to it's a very factual topic. Yes, so just try to go through these facts and go through these keywords that we are covering here. They are more than enough. You need not memorize everything in this case. Okay, so recently UN backed Kanhari, because in short we call it Kanhari. Uh, it calls for the Global Alliance of National Human Rights Institution. They deferred the accreditation of our NHRC. Yes. Now, what is NHRC? It is uh, basically a global network of all the NHRIs in, all over the globe. Yes, so they are non-profit entity, and they sort of coordinate between all the NHRI all over the world for the protection and upliftment of human rights. Now, it is a statutory body in our country. Basically, the object is to promote human rights, to protect human rights. Now, what are human rights? Uh, as per PHRA, it includes rights relating to life, relating to liberty, relating to equality and dignity of an individual. So if there is any such right which is getting violated that has its impact on the right to life, liberty, equality and dignity, it would amount to violation of human rights as well. Now, here I've provided you with the composition. Just go through it once. You need not lose your sleep over it unnecessarily. पूरा पढ़ के याद करने की जरूरत नहीं है. You need not memorize it. Just go through it just so that you internalize a sort of image of NHRC in your mind. That's it. Like it has Chief Justice of India as well. It has judges from Supreme Court. It has a person, Chief Justice from High Court. There are three members who are supposed to be a woman. I mean, all of them should be, uh, 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 experts basically, out of which one should be woman. Other than that, seven ex-official members are also selected. So all of this, just create an image in your mind, and that is enough. Talking about appointment, again, it is appointed by president on the recommendation of a committee. Now, you need not remember all the members of the committee, just prepare an image of how this committee would look like. Just imagine a committee with Prime Minister as its chairman, and then Union Home Minister, uh, member of parliament from Lok Sabha, Rajya Sabha, speaker from Lok Sabha, deputy chairman from Rajya Sabha. Just imagine how high profile this committee is going to be, and that committee recommend to the president for the appointment of NHRC members. Yeah, so it is a high profile body. Uh, Very important. Other than that, how do they basically work upon it? What all do they focus upon? They focus on the of research on several topics of human rights. They visit jails and study the conditions of all the inmates there. They spread awareness. They conduct awareness, and education is also very important motto of their programs. Other than that, they also indulge into some NGO kind of work with these kind of organization, and they try to encourage NGOs to work more towards human rights per se. Yes. Next one was use of regional language in the courts. Again, there was a time when this topic actually got a blow. So becomes important from exams perspective. You know, get a passage on this. Uh, Firstly, uh, let's talk about how do we decide what kind of languages are to be used on courts. Means does law say about it? So Article 348 talks about it. So Clause 1 says that all the proceedings that are taking place in Supreme Court and High Court is to be conducted in English. But there's Clause 2 to it that basically says that governor firstly takes some consent from the president. Yes, and then he or she, the governor, authorizes the use of Hindi or any local language or any such language for the official purpose in the High Court. Yes, so that is about it. Other than that, we have a statute, Official Language Act 1963, which gives some powers to governor to take consent from president, and then allow the usage of Hindi or any other official language in a particular state, but it has to be in addition to English, not only official language or not only Hindi, but there has to be English along with it. And that language should be used for the purpose of judgment and decrees and orders about that in the High. Yes, another one is about the subordinate courts. Now, there, what kind of language has to be used? It is decided by the state court. As simple as that. Okay, High Court and Supreme Court, you see, it is basically English, and if any official language has to be used, governor would decide that. Governor would authorize it. But when it comes to the subordinate courts, in that case, state government comes into the picture, and they decide what language has to be used. Next is Delhi government versus Lieutenant Governor of Delhi. That was a case. Again, a case which was debated so much throughout all the newspapers, on the news channels, and it was basically everywhere. All the politicians, there was a tussle that was going on between both the parties. I hope you know what kind of tussle I'm talking about, just in case if you're following news and politics as well. Now, what happened? So there were certain, suppose IAS officers, yes, they get appointed in particular city, such as Delhi, right? So in Delhi, there was this tussle between between the central government and the regional government as to who will govern those officers, right? Whose command will be followed by those officers. So this became a problem. This became a debate, and hence, at the end, of course, our Supreme Court is always there to solve all these kinds of stupid debates, right? So Supreme Court took up the matter because it saw how dirty politics was getting around it, right? And it was causing a good amount of law and order problem in Delhi. So at the end, this entire judgment was given. So giving you some details about the background, I told you there was this tussle that was going on between both of these parties, and then uh, there were certain instances wherein Supreme Court gave some kind of judgment, but again some debate took place, and again, so that was basically continuing for a long time, and then it was mostly about who will take the control of Delhi administration and Delhi law and order, and who's whose the officials will be allocated by whom. It will come under whom, whether it will come under the Delhi government or the lieutenant government. Yes. Also about uh, the court took up a question on constitutional validity as well as to uh, there was a law. Yes, National Capital Territory of Delhi Amendment Law 2021, wherein governor was referred as government. Yes, so constitutional validity of that was also to be checked by the Supreme Court. Now, what kind of verdict Supreme Court came up with? It simply said that government shall be bound by the decision that was given by the Delhi government. Yes, but there are only certain subjects on which it could be bound. Yes, government will lieutenant governor, so he or she will be bound by Delhi government. See, this lieutenant governor is appointed by central government, right? So there's a person that is going on between them. Now, they would be bound by Delhi government in which all matters, in matters related to services, apart from public order, police, and that. Yes, so they look after all the services related matter, but there would be three exceptions: public order, police, and land. Now, look at the second state. Power of central government, that is at center, had exclusive legislative and executive control over services. Look at this. Relating to Joe Upperman in the previous line, all those three exceptions, yes, that is covered there. Means governor shall be bound by the Delhi government, means Delhi government gets the power to all the services except for those three uh, entities, and those three entities, the power related to those three entities are given to the central government. So this is what three powers and three entities were given to central government, other than that all the other services were given to the Delhi government. Now, this why this debate? Yes, central government, central state government. Why so much of debate and not just Delhi? In a lot of places, why do we see these kind of debates? Because federalism, right? We have to maintain federalism of our country, and in general, federalism when it comes to union territories, it is said that constitution is a federal constitution, but it is inclined towards unitary. Being unitary means center having no power. But Supreme Court here contradicted that notion, and it said that Indian federalism is not unitary. And if from now union government starts expanding its own power, it would be contrary to the constitutional theme of federalism. Yes, I hope you would have heard about quasi-federal country, right? We are quasi-federal state, right? Now, it means sort of that we are federal but not completely federal. But previously the notion was what? That constitution is a federal constitution, but inclined towards center. Now Supreme Court amended it, contradicted it, and it said that our Indian federalism is not unitary. And if the union government, if the central government continues to expand its powers, in that case, it would violate our constitutional theme of federalism. It's a very, very important judgment with that respect. Other than that, it was also said that in a country wherein the leaders are elected, those are elected democratically, in that case, there is a principle of triple chain of accountability that is followed. Yes, election brings these three kind of accountability. What kind of accountability? Political, administrative, and public accountability. So that also gets hampered when such instances, such kind of tussle goes on between central government and state government. Why? Because that principle of accountability, triple change of accountability gets happened. Now you don't know who is going to take what kind of accountability. And when there is such, vagueness of ambiguity about these accountability, what would it lead to? It would lead to very inefficient kind of work because anybody will do anything because they'll have nobody to be accountable to, right? So they are not answerable to anyone, they will do anything, right? Until unless they do not have someone people and they are going to be accountable, they would not take that responsibility so right? Other than that, there is another principle of collective responsibility, which basically means that uh, if uh, uh, the ministers, right? It basically says that in a party, if there's a minister, say a minister does something wrong, in that case, the entire party will take up for correcting them, or for take up the responsibility for that. That is what is collective responsibility. So that extends to the officers as well, right? Because uh, they are also answerable to ministers. So when an officer does something wrong, that responsibility shall be taken up by the ministers as well, right? Because they are accountable to ministers, right? So collective responsibility also gets hampered. Other than that, we have certain articles important. You need not memorize article, just know that it is there, right? Just know about its existence. That's it. Article 249 double A. It talks about the special status that was given to Delhi, where it was said that Assembly has the power to make laws with respect to density of Delhi, except for three matters again: police, public order, and land. Why? Because it was given to central government. We just covered that. Okay. Other than that, our LC, we have the role control, and they act on the aid and advice of our Council of Ministers. Also, they uh, refer a difference of opinion to the president also, just in case if there is any such difference of opinion that is happening on Council of Ministers. And other than that, how union territories are administered. So they are administered mostly by, not mostly, completely by president through the appointment of an administrator who represents president in that union territory. So that this is an important part, by the way. Other than that, in some of the union territories like Delhi and Puducherry, that administrator who has been appointed on behalf of the president to represent the president in a movie, that administrator has the ability to make laws and regulations for UP, right? But other union territories apart from Delhi and Puducherry, that administrator has a very limited power for making such laws, right? Because they are supposed to do more as per the advice of the state government, right? So that also comes into picture. So yes, that would be it for today's session, guys. Thank you so much. I'm going to come up with another session next week. Keep updated with all these legal updates. Other than that, I would also urge you to go check out the playlist because very important topics have been covered in all the previous legal updates videos. Just go through it. You can watch it on 2x speed, cover all of them if possible. I don't know whether you have time now or not, but please take notes of everything that we are studying. I don't want elaborated notes, not at all. You may just make a note of simple one pointers, point wise keywords. That's it. So that whenever you look into it, whenever you look at those kind of points and pointers and those keywords, you would automatically recall whatever we discussed in the session. It is going to be very, very helpful for you in the not video, right? So yes, that would be it. If you have any questions, please feel free to ask me in the comment box below. I will be more than happy to help you out. Other than that, if you need any other kind of help with respect to CLAT or IELTS, please let me know in the comment box. I will try to help you out with that as well. Yes, so that's what we do from my side. See you in the next class. Thank you.